Honorable Judges of the Court of Appeal, Judges of the High Court, Deputy Registrar, my colleagues, Registered Magistrate. My name is Upenda Ongitiri. It's a great honor and privilege to stand before you to present briefly on IP litigation, the judicial regulated Republic of Tanzania. Because we are behind the time, I'll go quickly, just take you through the trend of IP litigation here in Tanzania. Let's start to identify laws regulating IPRs Tanzania. The main legislation regulating IPRs is the Trademark Service Marks Act, Copyright and Neighbor Rights Act, the Patent Act, Mechanism Act, and the Fair Competition Act. These are the main legislation used in court. But we have also other pieces of legislation. We have also several rules that have been made under those legislation. As you can see, because of time, I will not go through the listing identified above. Let's say judicial IP administration structure. The first instance court with jurisdiction to entertain IP cases at the primary court. This court has original jurisdiction to entertain copyright cases, but the position is before 2019, primary courts had no jurisdiction to deal with copyright dispute. The law was amended in 2019 to empower all courts to entertain copyright cases. So that's the position now. The next is the district court and resident magistrate court. These have concurrent jurisdiction. They have jurisdiction, original jurisdiction on copyright cases and appellate jurisdiction, and then appeal from primary court. After the High Court of Tanzania, the resident magistrate district, we have a High Court of Tanzania. It has original jurisdiction over all intellectual property cases, including copyright, trademark, patent, trade secret, industrial design, and and a patent. It has also the appellate jurisdiction on civil and criminal cases from the district court and RIM's court. But apart from that, the High Court is vested with jurisdiction to entertain appeals from the decision of the register of the trademark and service mark. We have several cases that have been appealed against the decision of the registrar of trademarks. The High Court has also jurisdiction to entertain matters referred by the registrar, and especially, normally these are those matters which involve a point of law. After the High Court, we have the Court of Appeal. This is an apex court in our country. The Court of Appeal has power to entertain appeals from the High Court of Tanzania, and we are very glad because we have some cases that have been adjudicated by the Court of Appeal recently. The dominant IP disputes in Tanzania are the trademark infringement and the copyright infringement. These are the main cases here. It's unfortunate that we don't have patent cases. I think because of the level of the development, we don't have much invention in Tanzania. That's why you find that most of the cases are just copyright cases and trademark cases. We have also some few cases on the industrial design and trade secret. The most aspects of trademark dispute in Tanzania, you go through the cases that have been filed before our courts, you find as well like similarities between trademarks, trademark offending procedural requirement, fraudulent registration of trademark, and appeals against the decision of the register of trademark and service mark. And we talk about copyright. We have most cases find unauthorized use of musical work, also communication of musical work to the public without authorization, or communicate to the public of films work without authorization, and unauthorized use of artistic work. We have several cases on this aspect. But we have also unauthorized the reproduction of literary work, and we see some cases. The next slide about this aspect. Let's see now the national jurisprudence on intellectual property. This part will highlight IP jurisprudence in Tanzania. Recently, there is an increase of on IP infringement related cases brought before courts for determination. In Tanzanian courts have decided several cases which have strengthened IP jurisprudence. Below, just see some of the cases among so many cases that have been decided by the High Court of Tanzania and the Court of Appeal. I would like to start this interest case. That is Jutoram Kabatale versus Vocation Education Train. In this case, the appellant or the corporate owner of the literary work, which contained the 5 road traffic signs for people with disability. And he stood the corporate infringement suit at the High Court of Tanzania, claiming that the respondent reproduces literary work in the book titled Taaluma ya Madereva Toleo la Pili without authorization and sold it for gain. The appellant lost the case at the High Court, but when he appealed to the Court of Appeal, he successfully appealed against a decision of the High Court. The Court of Appeal held, among other things, that after hearing both sides, the Court of Appeal held that the act of the respondent produced, distributed the work that contained the appellant recognized creative work without the consent was an infringement of the appellant copyright. The court held further that copyright infringement demand evidence of the defendant access to the original work and substantial similarity of the defendant work to the original. This is the case that was just decided recently, and we are glad that it was decided by the Justice of the Court of Appeal who is out today. Let's see another case. Just give some few cases on this part because of time. The next case is the Tanzania-China Friendship Textile Company Limited versus Nida Textile Mill. And this case, the plaintiff Tanzania-China Friendship Limited filed a suit against the defendant Nida Textile for infringement of the plaintiff artistic work. It was contended that the defendant copied the plaintiff design patterns of its printed fabric, popularly known as kanga or kitenge, created by the plaintiff lawyer. In his defense, the defendant denied to have infringed the plaintiff copyright and alleged that the design pattern on their fabric were drawn by local artists. After hearing both sides, the High Court of Tanzania deciding that where the author or creator of the artistic or literary work is an employee, the employer is still considered to be the owner of the right. The court held further that infringement of copyright arises or occur where a party, not owner, exploit the copyright without permission. Let's see another case because of time. Let's try to select few. Let's see the case Anselm Tryphon Gaiza versus Soge. In this case, the plaintiff filed a lawsuit against the defendant for a copyright infringement of their musical work. And it was alleged that the defendant has used the plaintiff's song in a movie that was produced in Song 2005. The plaintiff prayed the court to order the defendant to pay a sum of $10 million. The defendant raised the preliminary objection on the ground that the matter was time barred, but the court held that the movie is not something which is played once and banned. It is something that is produced, distributed, and more copies are being made and played from time to time. So the nature of this infringement, in fact, that there is a continued work which constitutes a new cause of action every time the movie is played. So you can see issues on time, on you can find that there is a jurisprudence developed here regarding copyright, especially when you talk of movies. The next case, let's see now some trademark cases, some few trademark cases, beginning with the Double Holding Limited versus East Africa Spirit. This is one of interest case, and this case, the plaintiff and defendant were manufacturer of a gin and spirit. The plaintiff registered the expression chasse asse of diamond as a trademark, while the defendant registered white diamond and diamond rock as a trademark. The plaintiff brought a suit against the defendant, claiming that the word diamond used by the defendant in his trademark amount to infringement of his trademark. The court, after hearing both sides, held that the mere use of the word diamond was not enough to prove infringement, unless the plaintiff established misleading similarities. The plaintiff trademarks contained the word diamond, included other words, signs, and symbols such as chasse asse of diamond, which are different from the defendant trademark, which consists only of the two words diamond rocks. If you read this case, there are several principles that have been developed by the court, and that's one of them, that when comparing composite trademarks, a court should evaluate them in their entirety rather than dissect them under the rule of anti-dissection. When you read this case, you'll understand what's the rule of dissection. The court held further that when evaluating similarities between trademarks, a court may be guided by the first syllable rule before declaring that there are glaring similarities. So, if you get time to read that case, there is a lot. I have just highlighted some. The next question is the recent case that was decided last week by the High Court of Tanzania. Is it Tiffany and Company versus Frisco's? The respondent filed an application for registration of a trademark, Tiffany and Company Hotel, before the registrar of the trademark and service mark. The appellant opposed the respondent registered, contended that the appellant was the lawful proprietor of the trademark Tiffany and Company, and its trademark has been used since the year 1837 in New York and the United States of America. The appellant contended further that his trademark has been registered in many countries, including Tanzania. The matter for opposing registration was dismissed by the registrar of trademark with costly, but when he appealed against that decision, the High Court of Tanzania held that in all intent and purpose, the respondent trademark, which is sought by the respondent to be registered by the registrar of trademark, service mark, is a counterfeit trademark or service mark intended to deceive client that the hotel business is linked with the appellant, while in fact it is not. As I said before, the High Court has the jurisdiction to entertain appeals against the decision issued by the Deputy Registrar of Trademark. So this is one of the examples of the cases, and we have also so many cases that have been filed before the High Court. Let's see also another case, the Glasgow Group Limited versus Chemical and Pharmaceutical Limited. And this case, the respondent applied for registration of a trademark Rantac in Class 5. And the appellant opposed the respondent registration, contended that they are the lawful owner of the trademark Zantac in Class 5. The goods enlisted in the respondent application were similar to appellant pharmaceutical, medicinal, and veterinary preparation and the product. They are likely to confuse the public. After hearing both sides, the High Court of Tanzania held that goods or services registered under the same can be the basis to determine the reasonableness of trade or service mark. And the two trademark is used simultaneously in the marketplace, and they are likely to confuse and deceive consumers. The court then decided that using the trademark Rantac, which is more or less similar with the applicant well-known mark Zantac to sell similar goods will confuse the public. So you find that this area is very sensitive, because you imagine that you have counterfeited medicinal products. That's very risky. So you can find that this area, IP touches all aspects of life, including health and other areas. Another case, this is the last case because of time. Let's see Tanzania Steel Pipe. Let's see one case on the trade secret. This Tanzania Steel Pipe Limited versus KK Wong commercial case number 41. In this case, the defender was employed by the plaintiff as a technical director, and the process he became privy to the confidential intellectual property of the plaintiff. Upon his termination, he started dealing with companies in South Africa and Botswana with the view to establish factories in Tanzania for supply products similar to those manufactured by the plaintiff. The defendant was liable for infringement of intellectual property. The High Court of Tanzania, in this case, held that secret information cannot be used for a different purpose without the authority of the owner. And the court held further that confidential information is a category of intellectual property which needs to be protected. These are just a few cases. I have tried to cite very few cases because of time, but we have so many cases in this area. And as I said that recently, there are so many cases that have been filed before our court. So this is just in my presentation, just to show the trend of IP litigation before we start this session. That is the end of my presentation. Thank you very much.